Hi, it's Connecticut personal injury attorney Ryan McKeen here. Today I'm going to talk about common documents that you might find when you're signing up with my firm or another car accident firm or another personal injury firm. When you've been hurt, you've contacted them, you may get some sign-up documents. And now in these sign-up documents, by law, all sign-up documents in Connecticut are called client agreements or fee agreements. Some of them may say retainer agreement. You may see headlines that say those things, but they're all the same thing. And what they have to specify are the fees that the law firm is charging, the way that they're charged, any sort of expenses, and they have to make clear to the client what it is that they are signing. And in personal injury cases, this is very different than other areas of law. Other areas of law, the law says you have to just disclose your fee. So if I'm doing a real estate transaction, I may send you an email and say the fee for this is $1,000, and that's okay. But with personal injury cases, the agreement has to be in writing and it has to be signed by the client. So you're going to have to sign that agreement. And we've done videos on this where there's waiver agreements and non-waiver agreements. Basically, the statutes of Connecticut, they specify that in a basic simple case, there's a fee agreement that says it's a third of the first $300,000, and then of the next $300,000, it's 25, and then 20, and then 12%. It goes down on sort of a sliding scale as the amounts get up. Or there's a waiver, and in the waiver agreement, which are common in complicated cases where there's a lot of experts, malpractice cases, it would be a straight third fee to the lawyer. But regardless of what it is, it has to be in writing and signed by the client. One of the other forms that you're almost certainly going to be asked for at any firm, and definitely mine, is you're going to have to sign a release for your medical records. So you might see a high-tech release or a HIPAA release, those being the two most common, but there has to be some ability for the law firm to go out and get your medical records, because that's a big part of what the law firm does in terms of gathering information in a case, which is get these records. So I think what you need to expect is you're going to expect to sign this, because the alternative is you've got to get all the records, and look, you've been hurt, you're trying to get better, and you're hiring a firm to do this for you. They should be the ones to do it and make sure that those records are complete. So expect to sign some authorization to get your medical records. A third one that we have signed at the beginning, we only have 3 at our firm, but there could be more, is the employment authorization. Sometimes there needs to be a lost wage claim, and sometimes actually it takes us a very long time to get lost wage information because companies have better things to do than send out your wage information to a personal injury lawyer. So it gets put on the back burner. So one of the things that we can do is we have the authorization signed up front, and if we need to use it, we do. If we don't need to use it, we don't. But you can probably expect to sign some sort of wage authorization. So those are really the 3 things: a client agreement specifying the fees, medical records release, and probably an employment authorization. Some firms may have you sign a release for your IRS tax returns up front. We don't have that signed up front. If we need to get it later, it's easy enough to get our clients to sign that later. There may be some other documents that some firms may have you sign for Medicare. We don't need those based upon our systems, but that we may need something down the road from you. But generally speaking, we try to keep it simple up front. So that's what you can expect. If you have any questions, don't hesitate to give me a call, 860-471-8333.